Many taxpayers mistakenly believe that if they receive a letter from the IRS, they're automatically being audited. Well, that's not always true. Some IRS notices are routine, others carry strict deadlines, and serious enforcement risk. And confusing one IRS letter for another can create expensive mistakes. Today we're going to explain which IRS notices matter most and how to properly screen them before you respond. Hi, I'm David W. Klossing. I'm a dual licensed tax attorney and CPA, and I'm the owner of the tax law offices of David W. Klossing. At this point in time, 24 offices, 11 states. In this video, we're going to break down IRS notices taxpayers commonly confuse with audits. We're going to look at what deadlines matter the most and when an IRS notice may signal serious legal risk. Well, what's the first step? Verify the notice you're looking at. Also know this, the IRS typically contacts taxpayers by mail first. So, if you receive an unexpected call, a text, or an email claiming to be the IRS, you should immediately proceed cautiously. Lots of scams out there. Start by confirming the notice or letter number, the tax year involved, and the response deadline. These three main data points usually determine your risk level and your procedural rights. So let's talk about the IRS pipelines involved here. IRS notices typically fall into three main categories. There's matching and automated adjustments via CP 2000. There's examinations, also known as audits, and then there's collection and enforcement. Identifying which pipeline that notice is coming from is critical before responding, because each pipeline requires a different strategy when you respond. CP 2000 notices, I've got a separate video on that subject. One of the most misunderstood notices is the CP 2000. A CP 2000 is not technically an audit. It's a proposed adjustment that they arrived at by comparing third-party information against your return. However, if you ignore or mishandle a CP 2000, things can escalate into additional tax assessments, penalties, and interest. So, while not typically labeled an audit, a CP 2000 should be treated with the same level of care as an audit. Well, the next pipeline is math error notices. Math error notices create another trap. The IRS can and does assess additional tax based on perceived clerical or calculation issues in your return. And taxpayers often assume they have plenty of time to respond to these type of notices. But in reality, you often only have 60 days to request a correction. Missing that deadline can limit your options. The next pipeline is the identity verification letters. Identity theft is a huge problem these days. Well, identity verification letters create confusion as well. Notices like CP 5071 are asking taxpayers to verify their identity. They do not accuse you of anything, okay? Don't freak out thinking they're calling you fraudulent. But ignoring this type of notice can delay refunds and create additional correspondence. They're just trying to verify that you are who you say you are. Not because of anything you may have done, because of what cheats have done. Correspondence audits. Some notices are actual audits. Correspondence audit letters request documentation and proposed adjustments if you don't provide it. Listen, after this type of audit, you may receive a 30-day letter that gives you the opportunity to respond or to request appeals. But the most critical document that you can ever receive from the IRS is a notice of deficiency. This is called the 90-day letter in the profession. This notice creates a hard deadline to petition tax court. Miss it, and you're SOL. Whatever they've done, mess up the law, mess up the facts, they can assess additional tax penalties and interest and begin to collect immediately if you don't request a tax court petition. Missing the deadline can severely limit your options. The next pipeline, collection notices. Collection notices are often mistaken for audits. These type of notices include CP 14 balance due notices, CP 504 intent to levy notices, and final notices such as letter 1058 or LT 11. These letters signal collection enforcement risk, including bank levies, wage garnishments, and federal tax liens. Responding correctly, and it can accelerate enforcement actions against you. So, when does risk become serious here? Well, some notices may signal heightened risk, especially where they involve unreported income, issues involving cash-intensive businesses, issues involving unpaid payroll tax, or repeated mismatches between third-party data in your return. At that point, what appears to be a civil issue can evolve into a criminal tax investigation and prosecution. So in closing, if you received an IRS notice and you're unsure how to respond, early guidance is critical. At the tax law offices of David W. Klossing, our dual licensed attorneys and CPAs screen notices, we protect deadlines, and we build response strategies that reduce your overall risk, civil and criminal. If you need help, call 1-800-681-1295 or visit our website, klossing-associates.com, the Contact Us page, to schedule a confidential reduced rate initial consultation. Contact me today, you won't regret it.